Colleagues, does the microphone actually work? Does it work? I don't hear very much. No.
Can you try again?
Hello? Yeah, this sounds better. Yes, thanks. Okay, good afternoon, everybody. Welcome to this session of the EP inquiry. We're gradually approaching the end of the inquiry, but we still have a few interesting sessions ahead of us. Before I introduce this afternoon's program, I would like to say hello and welcome to the visitors group of Mrs. Morvai, all women, something, hello everybody, very good, very good. So colleagues, today the presentation of the oversight mechanisms of the German Bundestag has been postponed to a later meeting as they're all very busy in building a new coalition government. And the presentation of the working document by Mr. Moraes and Mr. Kirkhope on the scope of international, European and national security in the EU perspective has also been postponed to a further meeting, but still before the Christmas break, I believe, yes. So if you all agree, then we will adopt the agenda with these modifications, no objections. Then today we have two sessions, one session in the series Oversight of Intelligence Services at National Level in an Era of Mass Surveillance. We will listen to a statement by our guest, Mr. Michael Techner, member of the Standing Committee on Scrutiny and Constitutional Affairs of the Stortinget in Norway, which is the Norwegian Parliament. And the second session from 4 o'clock onwards will be dedicated to the presentation of the working document on US surveillance activities with respect to EU data and its possible legal implications on the existing transatlantic agreements and cooperation, co-authored by our rapporteur, Mr. Claude Moraes, and the shadow, Mr. Vos. And then we aim to end the meeting at 5 o'clock. I see that we are not very numerous in terms of MEPs present, but I would still like to ask you when we get to the questions and answers to be concise, and I promise you if we have enough time, and I think we will, that you can come back for a second round if you feel the need. So it is a pleasure for me to welcome Mr. Michael Techner. I'm going to give you the floor for a short presentation on the oversight mechanisms in Norway, and then we'll open the floor for questions and answers. You have the floor.
Yes. Thank you very much for your introduction, Madam. Norway is not yet an official language of EU, but some one of us are working for Norway to join someday. In the meantime, I will prefer to use my Danish mother tongue in this presentation. So if the interpreters are ready, I am ready.
Firstly, I would like to thank for the very nice invitation we have received to meet here and explain the Norwegian Parliament and the control function of the Norwegian Parliament as far as the intelligence and security services are concerned. Control is one of the most important tasks of the Norwegian Parliament. We also have acts of parliaments and the state budget. But control means that we check that the government policy takes place on the basis of the acts of parliament. We have 12 parliament committees in the Norwegian Parliament, and control is very important. It is the Control and Constitutional Committee, and that is the most important of the committees. We also have 4 external organs carrying out control on behalf of Parliament, and the most important of these is the Norwegian Court of Auditors. And furthermore, we have an ombudsman for the civil administration, and we also have an ombudsman for the defense. The fourth organ is the so-called EOS committee, after the Norwegian acronym, and that is the subject of my presentation. This particular committee controls the intelligence, surveillance and security services, hence the Norwegian acronym EOS, the EOS committee. This particular committee was established in 1996, and the legal basis for that committee is a special act of Parliament that is passed by the Norwegian Parliament. The background for the establishing of this particular committee was a very wide-ranging public debate concerning the activities of the secret services in Norwegian. There was a lot of criticism, which meant that the Parliament in 1994 established a commission to have a look at the services, the secret services. The report from this commission, after 2 years of work, concluded that the police surveillance service, especially in the 1960s and 1970s, had carried out very substantial and illegal political surveillance. This surveillance was directed at people and organizations on the Norwegian left wing. One of the results of this parliamentary debate was the establishing of the EOS committee. For the very first time in Norway, parliamentary control was introduced as far as the secret services were concerned. That is really the borderline between the bad old days and the new parliamentary control. The EOS committee is a permanent committee of Parliament. The members are selected by Parliament for a period of 5 years. There are 7 members, and we endeavour to have about half of the members as politicians. Often they are also former members of Parliament. The other half of the committee we find in the Norwegian society former judges, researchers and whatnot. There's also a secretariat, mainly staffed by lawyers, and the members have maximum security clearance, and they are subject to strict rules of confidentiality. The main purpose of this particular committee is to safeguard the citizens, is to protect the citizens. It's a protection of the citizens against the surveillance services. We want to protect people's rights against the surveillance services, so that the same services do not hurt the political life in Norway. Over and above that objective, we monitor the adherence to the law. It's a general control. It's not limited to certain services. The criterion is that if a state service deals with surveillance or security, it is subject to parliamentary control. Most of the control deals with the traditional secret services like the police intelligence unit and the military intelligence service. The committee has 3 ways to control. There are inspections, approximately 30 every year, 30 inspections per year, and secondly, we treat complaints from citizens, roughly 20 to 30 every year, and thirdly, the committee can begin its own investigations, about 20 every year. The committee has almost unlimited rights of inspection and has access to all archives and registers. They also have access to all buildings and facilities. And the committee can also invite the services and the administration to explain what they are doing, subject to the usual rules concerning witnesses in court. There's a framework for inspections. We have to inspect the police intelligence service at least 6 times a year and the military intelligence twice yearly. Over and above that, the regional organizations of these services will also be inspected. As a main rule, inspections must be announced in advance, but there's also access to there's also a possibility for surprise inspections, and that actually happens quite often. If a citizen believes that he or she has been wronged by one of the EOS services, that person can complain to the committee, and they will deal with all complaints within their area. There's been roughly 20 complaints every year, and the complaints may lead to criticism of the services. But as I said, the committee can also start its own investigations, and over the last couple of years, 3 such own initiative reports have been handed into Parliament. That was firstly the Police Intelligence Service methods. The committee was of the opinion that the legality of the methods should have been evaluated before the so-called Treholt case. And the committee said that the police had the right to listen to phone conversations, but not to what happens in rooms, or it happens in people's houses. The second own initiative report was the police registration of 2 Islamic groups. And the committee looked at the treatment of religious and political views in the police registers. And the conclusion was that in certain cases the police intelligence service went too far and registered information that were of little relevance to the case in point. The third report had to do with surveillance and registering of Norwegian citizens in the street in front of the American embassy in Oslo. The police was criticized for not having the correct information as to the security system in the embassy and lack of communication with the Ministry of Justice. At present, the committee has 2 cases. One of them is a case with police informants that have infiltrated the extreme left. Information to that effect came out in a TV news emission, and the committee looked through the archives of the police and had interviews with police staff. The second case has to do with the intelligence service. There's a case that the archives are not in accordance with the rules, and 2 unannounced inspections were carried out because of citizens' complaints. The EOS committee has, over the last couple of years, established a cooperation with other control committees, such as Sweden, the Netherlands, Canada. All of them have committees that look a lot like the Norwegian EOS committee. There are many ways to control the security services. But regardless of the models you choose, there is a common objective You work on behalf of the citizens and their legal and human rights, which have to be respected by the security services. Security services cooperate to fight international terrorism. And that also calls for control of the relationship between different security services, Norwegian and other countries, such as electronic information and hidden coercive measures. It's a question of finding the right equilibrium between the private lives of the citizens and the need of the state for protection. Everybody agrees that you need security services, and there is support among the general population. But the methods they use are very often controversial. Most of the people who are subject to surveillance will not be told that they are. And the objective of this particular committee is to evaluate these methods so that individual citizens are not wronged by the services. It's fixed principles that the committee reports to Parliament. The Parliament does not receive reports with secret information. The dilemma of Parliament is we have to have confidence in this committee since we don't receive the secret information. We'll have to believe what they tell us in the Norwegian Parliament. The EOS committee sends a yearly report to the Norwegian Parliament. It is filed with the Control and Constitutional Committee, of which I am a member, and then that particular committee writes a project of a resolution for Parliament, followed by a plenary debate where the Ministry of Justice, the Minister of Defence participate. So there's ample room to discuss the activities of these different secret services. There's broad consensus in Norway that democratic control with the secret services is of major importance if we want to protect our democracy. The Norwegian model, with a control committee selected by Parliament, has been a success in our view. It's a very demanding objective for this committee, and they need actively to take up cases within the framework of the mandate. And the control activities of the EOS committee is a very important contribution to confidence in and understanding of the secret service as befits a democracy wanting to protect itself against international terrorism. Thank you.
Thank you very much. Can I ask you to switch off the microphone? Okay, thank you very much for the very...
Ευχαριστούμε πολύ για την ενδιαφέρουσα παρουσίαση. Να ξεκινήσουμε με τους σκιώδεις εισηγητές που είναι παρόντες, ο κύριος Βος εκ μέρους του ΕΛΚ.
Thank you very much, Madam Chair. Firstly, Mr. Techner, thank you very much for your report to us. I have a number. Thank you very much for reporting to us. It's very interesting, and I just have a number of small questions. Firstly, I imagine that you're talking about a domestic secret service that you mentioned. Is there also a foreign-based secret service or an external service which needs to be protected by perhaps UN units, for example? Is that also covered by this control committee? And moving on to individual cases, how deep or thorough is the information that you obtain generally when it relates to individual cases? Furthermore, Since the Breivik case, has anything changed in Norway in the structure or the way that tasks are organized? Furthermore, you said that when you meet to respond to complaints that come in from citizens, do you also meet on the basis of any perceived threats, or do you only convene meetings on the basis of complaints that have come in from citizens? And what about non-Norwegian citizens? Can they also address your committee?
Thank you. Mr. Techner?
Yes, jeg fikk kun på mitt øre.
I only got the German question in German in my earphone, but it doesn't matter. I do understand a little bit of German. But with that reservation, let me answer your question. Firstly, you asked me whether the control also dealt with the foreign intelligence operations. Norway is part of ISAF in Afghanistan, for instance. Yes, it does. As a matter of course. This particular committee has the responsibility for all security services, whether they carry out surveillance of Norwegians in Norway or abroad. But I don't think we control non-Norwegians abroad. There must be some sort of connection to Norway. Secondly, how far can you evaluate the methods? The answer is very far indeed, as far as the security services methods. And that goes for all 4 security services. The members of the committee have maximum security clearance as far as secret information is concerned. But in the report to the Parliament, they are deliberately vague as far as the secret information is concerned. And not names and stuff. And then the Parliament must have confidence in the evaluation and hope that the more vague terms gives Parliament a general idea of what is going on in the secret services. And thirdly, the terrorist attack against civilians by this Norwegian, Mr. Breivik. Let me say about that in 2 areas there's been criticism of the police security, the police intelligence service. They were not careful enough, they were not zealous enough, and the head of the police intelligence at the time said that it was not possible to catch Mr. Breivik on the police intelligence radar, as she phrased it, and she was criticized for that, because it was no longer possible, it was not possible to have a Stasi-like system the way they had in the German Democratic Republic, and she was much criticized for that explanation. We don't want a surveillance society, obviously, but on the other hand, the police intelligence service, in this particular case, clearly hadn't seen the degree of danger. Mr. Breivik bought material enough to produce a major bomb with the results we've seen. I'm talking about his bomb attack against the government buildings in downtown Oslo. That was one part of his attack. The second part was the attack against the Socialist Youth Movement camp on the island. where he used 3 different weapons, and he was in legal possession of all 3 arms. We've had 2 reports about the Police Intelligence Service and the events of the 22nd of July, and both of them contain criticism of the police intelligence. Because of the lack of surveillance of dangerous people. It's also a problem that many mental cases carry out attacks, carry out atrocities without any political aims, and hence are not on the radar. And let me add that the whole debate, the whole public debate in Norway has changed. There's much greater acceptance of the fact that the police will have to know what goes on in Norway. They need the resources. There's much more understanding for the police and the necessity of resources to the police for them to follow developments. And don't forget that Norway was a very innocent place, naive, if you will. We have a confidence culture in Norway. Only the last couple of years have we felt the need that police must protect our politicians, for instance.
Can you switch off your mic?
Vad ska vi nå?
Okay, right language. Thank you very much. Now I switch hats and I will ask a few questions on behalf of the Liberal group as the shadow, and then I think the other members present have all asked for the floor. I expect Mr. Sippel also would like to put a question. Yes, okay. Okay, but first myself, not as chair, but as a shadow rapporteur on behalf of ALDE. First of all, I have 3 sets of questions, basically. You say your system works well. You feel that you have sufficient oversight, and the way you describe it, it sounds indeed very, very efficient. But what was your reaction to all the revelations of mass surveillance? In particular, as your country is next to another country, Sweden, which apparently is one of the major nodes in all the networks. And apparently this had already been, if I'm not mistaken, spotted by one of the people who triggered the Echelon investigation. So much of this was already known or visible to some extent. So were you taken by surprise? Do you have the feeling that this is something that you should have been informed about? Then secondly, you also mentioned, you say you have oversight over national intelligence services, but it's much harder to verify what happens as soon as there is cross-border cooperation. Clearly, this is one of the key issues, because even if there are oversight mechanisms, which in many cases are extremely weak, then, as soon as there is cross-border cooperation, that cooperation completely escapes any kind of democratic oversight. So have you developed any thoughts on that? And then finally, I also have a few questions about the Breivik case. I was wondering, you say there is greater acceptance now by the public of data collection, but if what I read in the papers is that Breivik had at some point already appeared on the radar screen of the security services. Now this is a pattern that we see in all major attacks, that the terrorists or the perpetrators were known beforehand to the security services. So if they had access to that information, if he had already been spotted, then then apparently they already had the information and the powers they needed. So why is then the response not, we need to improve the way we process that information, rather than saying, we need more data on probably innocent citizens, basically, making the haystack bigger, making it even more difficult to find out or to identify such individuals like lone wolves. And then my final question, we were always told that the so-called TFTP agreement or TFTP data, the agreement that we have with the United States, which is very controversial and which this House has asked for to be suspended, but we were always told that was essential in the case against Breivik, apparently not in preventing the attacks, but at least in the investigation and the prosecution, I imagine. And I would like to know if, in your view, there would have been other mechanisms, such as the mutual legal assistance agreements that exist between the United States and European countries. In your view, could other mechanisms have been used to ask for specific information about this specific case, rather than having this bulk transfer of data? Thank you.
Tack for...
Thank you very much for your questions.
Til det første spørgsmål.
First question. Whether we were surprised about the extent of the mass surveillance. The answer is yes, we were surprised. The Norwegian public opinion and the politicians are no more informed than the average newspaper reader. So when you see that there are secret channels leading from the major IT suppliers to the Norwegian state, secret channels with information about the customers, such as Apple and Google and Facebook, you name it, Microsoft. And that is not international surveillance, not looked upon as such in the United States, because these companies are under American jurisdiction, and that these same services will have to hand out information when asked to do so. 40,000 such requests were addressed to Google concerning information about Google customers. And that, I think, is a surprise for politicians as well as public opinion in general. In Norway, we have this special case that Sweden has passed a law that makes it legal to carry out surveillance of all the data traffic between Norway and Sweden. In the case of Norway, it's nearly all of it. Even the lines of communication between southern Norway and northern Norway go through Sweden, which means that the Swedish Secret Service can capture information, emails, telephone calls between two parts of Norway. And that is obviously a problem for a sovereign state. Sovereignty is not just a question of physical borders and the monitoring of who walks past your border, but also the virtual borders. Only in a sovereign state, only its own administration has the right to carry out surveillance of its own citizens to see whether they carry out something that is of police interest. It's a competence you have delegated to your own police. You cannot delegate it to another nation. Even a friendly nation, and Sweden is a friendly nation. We are partners in many ways. But it is, at the end of the day, the Norwegian authorities that look after Norwegians. And we have a new government, a non-socialist government in Norway, and part of their program is the question of the Swedish legislation, the so-called FR Act, the Defense Radio Surveillance Law of Sweden. That gives this particular Swedish facility the possibility of listening in on Norwegian communication. When you talk about cross-border cooperation, that is always a problem, but there's one principle we have to adhere to. You cannot just give a foreign intelligence service the right to enter your communication systems and go fishing there. That is a right reserved for the local security services, the local police, and under the democratic oversight of that country. As far as Mr. Breivik is concerned, the investigation was not much of a problem. He confessed, there were witnesses, there was an exact description of what the man had done, so from an investigation point of view, there wasn't much of a need for secret services. The question was then whether the police intelligence service ought to have spotted this development before these terrible acts were carried out. It's true that Mr. Breivik had a criminal record, but he was convicted of vandalism, tagging on a wall, but not terrorism. He was also without any political attachment. So that was another reason for not appearing on the radar. In many ways, he was a lonely wolf, and they are very often very difficult to spot. They are not part of an environment, so they are very difficult to spot. Echelon. Well, that started in 2001, and we have now moved far beyond what was Echelon. And then we have the so-called FRA Act in Sweden, which is a major problem for us in Norway as far as protection of human rights are concerned. Thank you.
Microphone. Okay, next speaker on the list. I have 4 speakers. I'll take them in the following order. Mrs. Morvai, Mrs. Zippel, Mr. Engström, and Mr. Enschu. Mrs. Morvai.
Thank you, Chair. I would also like to take this opportunity to speak Hungarian, my mother tongue. I would like to thank our Norwegian friend for the very interesting presentation. Question number 1. If this tapping case really shocked the public when it became clear that this was much more widespread than one would have thought, and it really has nothing to do with national security anymore, then how come that on behalf of the decision makers there is so little interest? What could be done about this? Out of the 80 members, there are only 4 of us present as members of parliament who care to show any interest in this issue, and this is not the first time that this has happened. So, to paraphrase the question, maybe Edward Snowden was right, and what he was afraid is going to come true, namely that the discovery of the truth is not going to lead to anywhere, even though he risked his life for the truth to be uncovered. My next question. If any member state similar to yours, which is in charge of control and supervision of the secret services or military and police services, trying to protect the rights of the citizens against any such infringements of rights, what would be your suggestions? How could we make it certain that this doesn't fall prey to the usual government versus opposition fight, but it really does protect the citizens against the abuse of power? My third and last question. The case concerning the protesters in front of the American embassy in Oslo, which really caught my attention. If I understood you correctly, this was an example of when the EOS committee had to look into the issue. If I understood you correctly, there were protesters demonstrating in front of the US embassy in Oslo, and people were and the secret services really followed these people, and some of the procedures were simply illegal. How did you come to this conclusion? What were these illegal procedures, and was there a public uproar when this was unveiled? Coming from a former communist country, we would have thought that this would never happen in the West, in a democratic country, but apparently it can. And if it does, what's the upshot of this?
Mr. Techner.
Tack. Yeah, this first.
Thank you very much. As far as the first question is concerned, why is it that you're surprised? And isn't there a major pressure from the public opinion to refuse surveillance? If the general opinion feels that something is important, they need to feel personally involved to reach the opinion that it is important to have the surveillance. Very often when you talk about short-circuit television, there are 5,000 cameras in Oslo, in the city of Oslo, in the streets. It started as a very controversial project, but people have reached the conclusion that street crime is down, and many citizens will say, well, I have nothing to hide, which probably explains that there's no political dynamism behind the point of view that these cameras must be removed. And I agree with the question that it ought to be uncontroversial from a political point of view. That's why we have a non-political EOS committee. They report to the elected politicians in Parliament, to the Parliamentary Oversight Committee, where we discuss with consensus. It's not so much government against opposition. We all work as elected representatives. Next question was the American surveillance. Of the area around the embassy in Oslo. That case is not finished. I don't know what the EOS committee will do at the end of the day. We don't know the conclusions. Apparently, the embassy, the American embassy, apparently carried out surveillance of all the streets around the embassy, not just in case of demonstrations against the American embassy. And the official Norwegian authorities were not informed of this surveillance. But that will be settled now, I'm sure.
Thank you, Mrs. Zippel.
Ja, vielen Dank.
Thank you. Well, I'd like to pose a number of concrete questions. Mr. Techner, at the beginning of your introduction, you tried to illustrate why in 1996 the EOS committee was set up. You talked about the threat of the Norwegian far left. That was one of the reasons you gave. Now, the act of spying on the left wing in Norway, was that something that the secret services carried out under their own initiative? Or was there some political force calling for that spying activity? Was there a specific initiative taken to try to set that process in motion? And with all of these questions, they have, of course, an impact on today's activity of the Secret Service. Now, is there a specific description of the mission and scope of the Secret Services, what they can do, what they can't do? And if such a mission statement does not exist, on what basis do you carry out your monitoring activities and assess whether or not the Secret Services are doing their job properly or going beyond their remit? Since 1996, the complaints lodged by citizens, have they increased in number? Has the scope or reason for those complaints changed in nature? And just to conclude, one final question. Quite a few months ago, maybe even years ago, here in the committee, in the Parliament, we had a debate on data protection and storage. And I remember a colleague mentioned a film that many people had seen. It was called Minority Report. I feel that this debate reminds me of that film, because I get the feeling that the services do today what we saw in that film. More specifically, they collect as much data as they possibly can from citizens, from institutions, from associations, and using that data, they try to profile a possible projection to see whether a crime will be committed or not. Now, if you can contradict me and say, no, it's only on the basis of a certain suspicion or a very concrete event, then that would assuage my fears. But I would be very interested to hear whether that plays a role in your work. Thank you.
Sure.
Tack.
Thank you. In 1996, what happened was the Cold War logic being continued. It was not so much a question of chasing harmless political groups on the left wing. There were all kinds of legal political activities on the left wing. But the opinion at the time was that if you have somebody and they spent their lives trying to squeeze Norway out of NATO, and that these same persons could probably have other objectives other than their political objective. It was a question of NATO and anti-NATO logic. And it was a fact that these were extreme left-wing groups, extreme in relation to the traditional left wing, i.e. the Labour Party, and it was assumed that they were a risk to Norwegian security policy. And then they exaggerated their activity, and that was the conclusion of the so-called Lund Commission. report. But let me emphasize in that connection that we do have procedures for surveillance of citizens. If you want to listen in on phone conversations, you want to listen to people in their homes or open letters, you need a court ruling. And what this committee does is to evaluate if the police has gone too far. The secret services, the security services need a court order in order to carry out eavesdropping. Complaints then. As I told you, we have about 20 complaints every year. And some of the complaints come from people who have a medical record on the basis of their own personal situation. There's not an awful lot of substance in their complaints. Let's say that 10 or 15 complaints are what I would call medical, for medical reasons. It's people who claim that they're being eavesdropped, and they tend to have the same contents, and it's the same number over the years. Also, the number of complaints, the total complaints, remain pretty much the same year after year. And I agree with you. You can be obsessed with the collection of information, and in the end, you lose. It becomes a haystack, and it's too big for you to handle.
Thank you. Mr. Engström.
Tack.
Thank you. I'm going to ask a question in Swedish. Now, as you said, the Norwegian authorities weren't able to prevent Breivik from doing his terrible deed. Were there any other cases? You said that one of the reasons this monitoring of Norwegian citizens takes place is to find terrorists and try and stop terrorist acts taking place. Are there any cases where you have been able to prevent a case of terrorism? Now, I'm sure that's a question you can ask, because Norway is a state ruled by which is governed by the rule of law. Norway doesn't carry out extraordinary renditions or that sort of thing. So if it had indeed been the case that monitoring had led to finding you to someone who was preparing a terrorist act, then they could be taken to court in Norway. So that's my first question. Secondly, Norway and Sweden have a lot of information exchange taking place, both on the military and civil side of things. And as you said, Sweden has a military intelligence law, and that gives it the right to carry out spying on Norwegian citizens as much as they want to, whether there's justified cause or not. So there's a question here again. Has any help from Sweden or the Swedish military intelligence law led to any convictions or any terrorist act being prevented?
Det første du siger,
To the first thing you said, one of the reasons why we didn't intercept Breivik's activities was that he had bought different remedies that any man could use or need. But what should have tickled our curiosity was the quantities in which he had ordered. And the police intelligence service wasn't ready enough. The main component of the bomb had been registered with the intelligence service, but it was normal or natural for someone in his line of business to have ordered that. And also, when you talk about surveillance, no one in Norway could have prevented the attack. Also, not after having cooperated with Sweden. So I can't say that. No, thank you.
I think maybe I'm not sure if your second question was fully answered. Whether there've been any, whether attacks have been prevented and whether there've been convictions.
Actually, I think it was. So the
Yeah?
Norwegian
Okay.
surveillance has resulted in no foiled terrorist plots, and as far as Norway is concerned, the Swedish mass surveillance has also resulted in 0 foiled terrorist plots. So, yeah, thank you for the answer.
Okay, then the last speaker on the list is Mr. Enshu. Oh, who's left, apparently. Okay, then that ends the debate for today. Thank you very much. I think that was most enlightening. Thank you for coming here. Colleagues, then that brings us to session 2, presentation of the first working document on U.S. surveillance activities and its possible legal implications on the existing transatlantic agreements and cooperation. One of the co-authors, namely our rapporteur, Mr. Moraes, is not here today, so I'm going to ask the other co-author, our shadow rapporteur, Mr. Vos, to introduce the document. And I believe, and I'm looking at the Secretariat, there is no document in the file. Is there? No. So it will just be an oral presentation. Mrs. Morva, you have a point of order?
Yes, please consider this a point of order. I must ask, why is Mr. Moraes not here as an author? I mean, I think this is really unacceptable what's going on here. Out of 80 people, there are 4 or 5
I don't
here.
think we can answer that question. I have no insight into the calendar nor the movements of Mr. Moraes. I'm sure he has very good reasons for not being here. So I don't think that I can explain, and I think you should ask him that question personally. But Mr.
This is not a personal matter. This is a very serious political matter.
Mrs. Morva, I cannot answer why anybody isn't present here. So I'm sorry about that. Mr. Vos, you have the floor.
So, vielen Dank.
Thank you very much. This first working document looks at surveillance, particularly data and the possible legal implications on the existing transatlantic agreements and cooperation. Now, before the summer break, we set up the Committee of Inquiry to look into the NSA issue as things came to light. Within that framework, we wanted to collect information as to the existing legal framework and how it would be affected in terms of the transatlantic agreement. And here we're looking just at the legal framework for data transfer between the EU and the United States to try to shed some light on the way that works, to look at particularly Safe Harbour Agreement, the TTIP Agreement, and the PNR Data Agreement to see how these would be affected. I'll begin with Safe Harbour. Now, the Safe Harbour Agreement is an agreement of economic nature which the United States Department of Commerce and the Federal State Commission for Transport have set up together with the European Commission. The agreement allows personal data to be transferred legally to US companies. The EU Data Protection Directive from 1995 prohibits personal data to be transferred away from member states of the European Union to third countries unless there is a level of data protection which is comparable with that of the EU in those third countries. Now, the Safe Harbour Agreement attempts to put in place a comparable level of data protection for that personal data and allows companies thereby to transfer data. The basic clauses of the agreement have to be respected under Safe Harbour, and it means that personal data relating to citizens of member states have to be protected accordingly. The Safe Harbour agreement is always subject to criticism and has been since the start. We carried out a few hearings on this matter, and the criticism has only worsened since the data revelations came to light. So even at the beginning there were criticisms, but the basic legal framework was considered to be sensible and the right data, the right framework for that data protection. Now, in the event of a breach of the agreement, Article 3 makes provision for the possibility of the Safe Harbour agreement being rescinded by one of the parties. And in the light of the NSA spying scandal, the European authorities carried out an assessment this summer. Last week that was communicated to us, and I'm very pleased to see that the Commission has produced this assessment together with 13 recommendations to improve the way in which Safe Harbour works. However, personally, I believe that these proposed approaches given to us by the Commission are not a satisfactory solution, because I get the feeling, and I think we gleaned this from our hearings from several different parties, we got the feeling that the Safe Harbour agreement is no longer safe. Firstly, the possibility of mining data is twofold. Firstly, there's the illegal possibilities that we've seen through the NSA, but there's also the possibility for data mining through the companies themselves that collect and store data. Increasingly, intensively, companies are using and mining the data for different purposes. If we look to the longer term, in order to protect the data of our citizens in a more effective way, I think we should suspend the Safe Harbour agreement and to set a new agreement up on a new basis, because this has not just political consequences but also economic consequences, and for our economic partners in the USA. In the short term, I believe that if we were to suspend the agreement or recall the agreement, there would be quite a considerable impact. The companies that are involved in the Safe Harbour agreement would be significantly affected. But I do think that in the long term, we have to make sure that an appropriate level of data protection is afforded to our citizens. They have to be better protected. Their data has to be used in a more serious way. And I think we have to find new solutions to this problem, because the Safe Harbour agreement is not a long-term approach. It's also important to restore the trust that's been lost between the transatlantic partners. Now, the second agreement that I'd like to address is the so-called TFTP agreement. This is particularly important in terms of relations between the EU and the US. This is an agreement on the payments and transactions data from one country to another, and the purpose of it is to fight against terrorism or large-scale crime. And perhaps just to add to what our previous speaker said, this may have helped in the Breivik case. Now, the European Parliament has already expressed through resolution its strong conviction that correct security measures need to be in place to try to ensure the protection of data properly. Also, at the same time, we have to ensure security while maintaining the highest level of respect for people's private sphere. That's something that the Parliament has already agreed to. We believed that what we needed with this transaction data was to deal with the question of terrorism properly, but also at the same time to ensure data protection levels on a comparable setting. Now, suspending this agreement in accordance with Article 21 would be possible. I would refer you to the EP resolution from the 23rd of October and the communication from the Commission that deals with the matter considerably. After the agreement is suspended in accordance with Article 21, certain measures would have to be taken as a follow-up. Now, Commissioner Malmström talked to the members of the committee in LIBE and told the members of the LIBE committee all about her exchanges with the American authorities. Now, they said that there is no justification for a suspension of the agreement in accordance with Article 21 following her discussions with the American authorities. We had a hearing with Europol and with the SWIFT company themselves, and we learnt that there were no indicators suggesting that the agreement should be suspended. However, if we look at the implications of the terrorist attack on the 9/11 and the financial flows that were involved in the run-up to that terrorist activity, then it's quite clear that this is an important area. The Commission will have to come forward with a proposal for a legal and technical document that would ensure the protection of data in this field. Now, personally, I think that the TFTP program is shaped in such a way that we have to make sure we've got a balance of security and privacy, and we need to make sure that we're on a par with the United States as to where they want to strike that balance. At the moment, the agreement doesn't target that particular goal. On the one hand, we've got the question of protecting our citizens, the security of our citizens, but on the other hand, we have to clarify, generally speaking, how we want to enter into agreements with the United States, given that the situation is not as we would like it to be in terms of security. So how do we get this balance between the different wishes and desires of the contractual parties? I'm not sure whether just suspending the agreement because it's not perfect for us at the moment is a good approach, because I think this would be more of an impact on our own citizens than the Safe Harbour agreement would be. Next agreement is the passenger name record data between the EU and the USA. Transfer of passenger data, this is data that is put together by the airline companies and transferred across. When the passenger books a flight, this is recorded on the airline's software and it's saved there. The agreement says that in accordance with Article 24, if there's a breach of the agreement, then the agreement can be rescinded. And then in Article 25, there is also a suspension clause. But there's no indication of what should happen in the event of misuse of data by the security services. There was a joint evaluation report issued by the Commission last week in which it quite clearly indicates that in 23 PNR data cases, so these are 23 cases where the NSA have asked for data from the PNR lists, and they've used that to fight against terrorism. and this is, by the way, my legal assessment, but they are in alignment with what the agreement was set out to achieve. So I think this is important to continue to use this agreement, to look at EU PNR agreements, and to perhaps look into this further. I think we need to work perhaps on having an agreement of this kind to avoid having 28 separate PNR agreements, which would be fragmented. Now, if we look at the way in which personal data are dealt with in the USA in terms of how that data is protected, well, that's clearly very differently protected in the US to the EU. They have a horizontal perspective on how to protect that data. They look at consumer protection from a very different angle. In the EU, we try to ensure consumer protection through legal standards and legal provisions, and the security aspect is given more priority from the USA side of things. In terms of the spying scandal itself, this obviously has implications on the private sphere of EU citizens, and it weighs heavily on the transatlantic relationships. The idea of suspending new or existing agreements, such as the safe harbour, is, in my view, possible, but we have to be prudent. I think if we suspend safe harbour, that may boost credibility from our side. It would also help us make one step towards restoring that trust and confidence that we need to. And finally, the so-called umbrella agreement needs to be concluded as soon as possible. This is an issue that Philip Albrecht has taken up. I believe that this is an important contribution that we can bring to the table in terms of the exchange of police and judicial information. It could also increase the protection level of personal data, and it will give EU authorities the possibility to get redress where there is misuse of personal data by the US. Thank you.
Okay, I have 3 requests for the floor so far. Mrs. Zippel, Mrs. Morvai, Mr. Engström. Anybody else wants to come in? No? Then I close the list and I'll add myself as last speaker as a shadow for ALDE. Mrs. Zippel.
Ja, vielen Dank.
Thank you. Well, let me respect the same order as Mr. Foss in his presentation of the report and ask a very brief question on the Safe Harbour Agreement. The recommendation is to renegotiate the agreement and dissolve the old one. So perhaps we could make it clear, why should we negotiate it again anew? Now, in the future, we hope we will round off and complete our data protection package. And if that is the case, well, for what cases would we need this? I think it's worthwhile thinking about that before we consider the legal consequences. Now, the legal consequences from the NSA affair should not be separated from the political consequences as far as I'm concerned. And when I hear people saying that announcing a withdrawal from the TFTP agreement shouldn't be seen as some sort of a revenge for the US behaviour, well, that makes me somewhat irritated. I think it was a European Parliament decision to call for that agreement to be suspended. Now, comparing that with some kind of act of revenge, I think is somewhat doubtful, given that there's been a debate about the value of that particular agreement for some time, and I don't think we should be pushed into a corner here in the Parliament, because after all, the decisions we take here in Parliament should be taken seriously. Now, the idea of following the money, and that being a good idea in principle, I don't think anybody would question that principle. Nevertheless, I would just say at this juncture that since the agreement has existed many have questioned its preventive nature, whether it actually is a good tool for preventing criminal activity compared with other aspects of the TFTP agreement, which I wouldn't like to mention right now. I think it's certainly interesting to note that the Commission has not presented any comprehensive research or report to show whether SWIFT data have been collected violating the terms of the agreement. Now, the firm looking after TFTP data has said that they haven't detected any violations on their server. That doesn't necessarily need to mean anything, because data could have been transferred from one server to another. And I don't know why it is that Europol and other cybercrime units have not been requested to provide any evidence or any information. We're just told, no, everything is fine. And it's all very well having trust in other institutions, but I'm not quite sure that is the end of the matter. Now, on the question of PNR data, now Mr. Foss said that we want to avoid a situation where we end up with 28 individual agreements. Now, I don't think that all member states are currently involved in setting up such a system, and if they were, what budget would they pay that from? Now, last week we heard from Mrs. Malmström that we're not thinking about mining TFTP data in Europe because there's no money available. It's too expensive. And so if we can't do that, if the Commission isn't able to do what we have explicitly given it the task and the mandate to do, well then where would we end up, from what budget would we end up funding a PNR system, which I don't think would be a good idea anyway. And one has to ask the question as to the use of this data. You know, it's more than doubtful that it'll be used to fight terrorism, this kind of PNR data. One shouldn't believe everything one reads in the media. There are all kinds of other lucrative ways this data might end up being used, and we need to bear that very much in mind and take a great deal of care here and make sure, firstly, we need to see whether the agreement has indeed been violated, and secondly, whether the whole agreement really should be therefore questioned. I think both of these points need to be intensively debated. Thank you.
Köszönöm szépen.
Thank you. If I get it right, we are now dealing with a draft report in the LIBE committee without the presence of the rapporteur, and we heard the presentation of the shadow. The title of this working document is USA surveillance activities with respect to EU data and its possible legal implications on the existing transatlantic agreements and cooperation. The shadow rapporteur, as the actual rapporteur is away, and so we cannot find out what he thinks. Well, the shadow said the following. On the one hand, he said that on information of the European Commission, they don't find it proven that any kind of serious violation has been committed on behalf of the United States with respect to European data. In other words, in the past 6 months or 3 months, ever since this committee has been involved in this issue, it has not been confirmed what Snowden and the media and civil organizations have said. Do I get it right? And what sort of procedure has been going underway? Has the European Commission questioned Snowden? How come we haven't questioned Snowden, although I have filed a motion to that effect? We would like to clarify this. What is being confirmed? What can we establish as facts? And what legal implications are there coming from these legal facts drawn by the European Commission and what is their proposal. If I read it well, nothing has been said to that effect. Whether we can suspend the effect of the transatlantic agreements, but I have the impression that we are in such a lukewarm situation. Only four or five of us are present, and consequently there won't be any implications. We are not saying that the United States was spying against the European Union. We're saying that only 1% of the Western world is spying against the rest of the 99% of the world population, and it's not a EU-USA issue, it's rather 1% against 99% issue. And that's what Western countries are doing, and our countries might be doing the same. And there is no resistance because everybody finds it natural. But I can only ask the shadow rapporteur if I am right. So these were my questions. How far has this committee has gone, and what will be the contents of this report coming out in January?
Before I give the floor to Mr. Engström, for your information, Mrs. Morvai, the arrangement for this committee is that the rapporteur and the shadow rapporteurs will jointly draw up a report. So Mr. Vos is the shadow on this committee on behalf of the EPP, but he's also the co-author of this document. So we're all writing parts of the final report. So you have listened not to an introduction by just any shadow, but by the co-author of the document. Mr. Engström.
Thank you. Well, unfortunately, I haven't read the working document since it's not actually available.
Well, you couldn't have read it because it's not available yet, and it will be made available before Thursday's meeting.
Exactly, yeah. But
I'm sure the NSA has read it.
Yeah. Yeah, unfortunately the problem is they don't seem to be sending me copies of everything they find out, which I find highly problematic, but that's the way the NSA works, I guess. When the document does become available, I do hope that it will be a bit more critical than the Commission, because to be perfectly honest, yes, I understand that Commissioner Malmström has been over to the US, she's talked to them, the Americans promised, no, we're not breaking any laws at all, and she came back and she says, oh, they say they're not breaking any laws, so everything is fine. To me, that comes across as the Commissioner being just a tiny bit naive. One could imagine, I think, that security services might occasionally lie to foreign powers when asked about their activities. So I'm unimpressed by what the Commission has done so far. And I would like to, again, coming back to a very similar point to the one I made in my question. When we had Congressman Sensenbrenner here the other week, he talked about how effective all this mass surveillance by the NSA has been. And as I understood him, there has been 0 cases of the NSA or the great US surveillance machine in general being able to actually stop a terrorist attack or foil a terrorist attack. Congressman Sensenbrenner said that there had been 1 case where the mass surveillance data had actually led to a conviction in court. But that was not for anything terrorism related, or it was not for terrorism charges. It was for some economic charges. So with this background, the TFT appears to have resulted in exactly 0 terrorist plots foiled worldwide. I mean, we heard there's nothing in Norway, nothing in Sweden, and from the congressman we heard, well, nothing in the US. The same would apply to the PNR. With this background that these programs don't actually seem to provide any security at all, shouldn't we consider, at the very least, suspending them immediately? Because, I mean, we wouldn't put ourselves at any great risk by doing so. That seems apparent to me.
Okay, thank you. And then with my shadow hat on, okay, the following points. So I won't say very much about safe harbor because I share the views expressed by the rapporteur and Mrs. Sippel and others. With regard to PNR, well, as rapporteur, I voted against the agreement, so I haven't changed my mind. Quite the opposite. So I think that should be suspended as well, and we should be looking at the other PNR agreements as well. Incidentally, I do not think that this report has anything to do with EU PNR, and I actually quite resent the suggestion that there is a need for harmonization between 28 different national systems because they don't exist yet. And in those countries where they're being created, like in my own country, without a legal base, the creation of such a system is actually being funded by the European Commission. I find that of an extreme cynicism. So, but I don't think that we should be addressing the EU PNR issue here. On TFTP, Mr. Vos, I do not think we're calling for a suspension by way of revenge. I think we're calling for a suspension because we feel that the Americans have not kept their side of the bargain, because they've broken the agreement. And because the European Commission is unable or unwilling, or a combination of both, to properly investigate and provide us with any good justification for not calling for a suspension. My fourth point is, why have you focused on these three agreements only? Why haven't you focused on other agreements with the United States outside the area of law enforcement and security? For example, bilateral agreements between the Member States and the United States on FATCA, their Foreign Account Tax Compliance Act, which is also collecting massive amounts of data, and I'm sure there are other agreements as well. And why haven't you included agreements with other countries which are engaging in mass surveillance, like Russia, for example? Because there's an agreement between Europol and Russia, if I'm not mistaken, and if I understand correctly, it hasn't yet entered into force, but is about to, or I don't know. But I'm sure there are other agreements with other countries other than the US that we might wish to look at. Then I think there are my two final points there are some conclusions that we should draw for the future, lessons to be learned. First, I think we should be looking at the role of the European Parliament in the conclusion of international agreements. And I think there's a very important lesson to be drawn from the TFTP agreement, namely that once we have put our signature on such an agreement, we're out of the game. And I feel, as a member of Parliament, that I don't sign blank cheques. If we give our consent to an agreement, then our responsibility doesn't end there. We're not a rubber stamping machine. And I think this is something that we need to discuss for future agreements. What is our role? I mean, we've been given powers by the treaty to approve the conclusion of international agreements. But now that we find that once we've done so, there's nothing more we can do, then, I'm not so eager to sign up to any future international agreements of any kind. And that needs to be clarified. And there, we've asked, you may remember that I believe it was the US PNR agreement, where we asked the European Commission to commit publicly to put forward a proposal for the suspension or termination of an international agreement should the European Parliament ask the Commission to do so. Now we have done so, and now we see that the Commission is not the least bit interested in the position of the European Parliament, because, hey, we're only the elected representatives of 500 million citizens. Who are we to ask for such a suspension? So this is something that definitely needs to be clarified. And then my final point is, if we allow the massive collection of personal data, or if we sign up to agreements on mass surveillance and what have you, then the other side of the coin is transparency. Because for me, the essence of democracy is checks and balances. You know, it's not just elections, it's checks and balances. If we give powers to public authorities, then we need to give powers to the citizens as well to defend themselves against mistakes, abuse, arbitrary use of powers. And here, you know, our laws are falling short of what is needed. We have a transparency regulation, but it turns out that in practice it is you know, useless, because every time there is any kind of let's say impact on the international relations with our friends on the other side of the Atlantic, any document relating to those international relations are almost automatically, they are routinely classified as secret and confidential. So that basically means that the US determine the level of transparency in the European Union. That's unacceptable. But we cannot blame our American friends for that. We have ourselves to blame, because we accept it every time. We accept that the clause for exemptions and exceptions in the transparency regulation basically means that the transparency regulation is null and void. Now, this is something else that we have to look at carefully, because we are currently, colleagues, looking at the revision of the transparency regulation. And I hear that some groups in this House say, you know, the talks have been stuck for so long, we need to bring this to a close before the end of the mandate. Therefore, let's give in to the Council, let's accept lower transparency standards, and let's just, you know, get the thing done and over with. And I think that is a very, very dangerous proposal, and it's something that needs to be addressed in the context of your text as well. So if there are no other pressing questions, then I give the floor to the rapporteur for concluding remarks.
Thank you. Let me just say that what this really is about is looking at the legal consequences of existing transatlantic agreements. And so really, that means we're focusing on quite a limited range. And some of the comments were much more to do with general conclusions about this whole process, which goes over and beyond the scope of this report. They were more political comments. Now, that's one thing. And furthermore, if we're going to talk about Russia, Europol, or agreements or other bilateral ideas, well, that would be a good other bilateral agreements. That would be a good idea, but then perhaps we'd end up having the results of our committee of inquiry in about 2 years' time. Given that there are 28 member states, looking into all of the bilateral agreements, well, there's a very large number. Well, Europol and Russia, that's not a bilateral agreement, says Mrs. Sintfeld. Well, no, but you said that other bilateral agreements perhaps ought to have also been looked at, and I think that would have gone well beyond the scope of this report. Furthermore, we weren't just talking about Russia, also the NSA and various other, and PRISM, for example, as well. So that really wasn't the task of this report. Now, moving back to the Safe Harbour Agreement, we always need to bear in mind the question of, well, unless, of course, you want this sort of thing across the board, but I think this sort of thing is unavoidable. Namely, that data is going to be leaving our continent one way or another. So how do we want that to occur? Do we have in either directive or the coming regulation where we talk about a transfer of data to third country needing to happen with adequate data protection standards? Now, if we're going to suspend Safe Harbour, then we're going to have to find some other basis for providing an adequate data protection standard to any data leaving Europe. Whether it's going to be called Safe Harbour or whatever is not the point. What we need is a jointly agreed data protection standard for any data that we pass on, which needs to have an appropriate legal basis as well. Now, on the TFTP program, well, there, and perhaps let me make a more general comment, in fact, first. There are two measures which overlap to a certain extent as far as our citizens are concerned. First relates to data being siphoned off from a network or from servers illegally, on the one hand, and we also have authorities going to large companies which specialize in data analysis and asking them for data. Now, in both of these areas, on the legal side, you just need to find a political solution for that, but when it comes to legal data inquiries, we need to make sure that they're on the basis of standards we all agree to. Now, if you move to the context of fighting crime or fighting terrorism, and you're dealing with data in that context, then you have to ask a question as to how we're going to exchange data with the United States. There's the so-called bank data agreement, SWIFT or TFTP, and if we are convinced that it is important for us to fight organized crime and clamp down on the financial flows supporting terrorism, then we need to be able to do this kind of thing. At the moment, the United States is doing this, and that's why we have an agreement with the United States. And at the moment, we don't have any facts apart from just a tip-off, if you like, in the Snowden paper, which talks about how you can siphon off data from various data streams. We have not really got any evidence that this has actually taken place. The Europol, SWIFT, the European Commission, the United States government, all of those bodies tell us that this has not taken place. Whether we agree, whether we believe that or not is up to us, but we don't have any facts, any hard evidence on the table which would justify or would allow us to suspend the TFTP agreement at the moment. And even though there's a decision of the European Parliament, I'm not sure if we want to set up some sort of data exchange agreement with the United States. On what basis do we want to do it then, if not this one? If we say, well, we found a good balance between allowing ourselves to exchange data and having a certain amount of data protection, if we found some sort of balance, are we just going to throw it away? And if we are going to throw it away, then what new basis are we going to use to find a new balance between data protection and data exchange? We've agreed certain standards, and they go quite far. And I'm not sure what alternative you're thinking of, those of you who would wish to suspend the TFTP agreement. I don't think there really is any other way forward if we want to monitor financial flows which could be used for terrorism. Mrs. Morvai, I think you spoke out in quite general terms. You talked about the conclusions of this paper, but we don't really have conclusions yet in that form. Currently, we're just looking intensively at individual agreements which we have entered into. And so I think what you talked about really relates rather more to the final phase of our report. Because I just don't think it's worthwhile at the current stage to debate as to whether the law has been broken or these agreements have been violated or not. Now, on the subject of SWIFT or TFTP, we don't really have any facts on the table. We don't have hard evidence to say that somebody has actually siphoned off SWIFT data. You might suspect that's the case, but we don't have any proof at the moment. What else do I have? Well, Mr. Engström, rather. The fact that we don't have the working document in written form, well, I do have it in front of me in writing, but right up until the last minute we've been working on it, so I do apologise that we haven't managed to get it printed out up to now. The original deadline was the 5th of December, and so we weren't able to actually round it off any more quickly. I do apologise, but I do hope that my oral presentation was clear. But perhaps here, let me say again that we are looking at the legal consequences of these transatlantic agreements or their suspension. When it comes to the political agreement, and then the question of what the role of the European Parliament might be in that context, or the question of transparency in this context, I think all of that is really stuff for the conclusions. That's what we'll focus on in the conclusions of this report, but not in this particular part of the report.
Okay, thank you very much. That basically brings us to the end of this meeting, 15 minutes ahead of time, which is not a bad thing. And then I can announce that the next hearing of the inquiry will be this Thursday, December 5th at 3 o'clock until 6:30. So thank you all and hope to see you Thursday.